Thanks to each of you for being willing to serve and for being here to answer our questions. Some of you might be familiar with a proposal known as the Smarter Act. The Smarter Act is a piece of legislation that would ensure that the Department of Justice, antitrust officials, and the Federal Trade Commission officials would have to meet the same standard when seeking a preliminary injunction to block a proposed merger, and would also require the FTC to litigate merger cases in federal court instead of relying on the administrative processes to which they have access. At some points in the past, I've discussed these proposals with individuals who will say, I don't necessarily see the need for legislation like that and don't like it because we don't need it to be that way anyway. We already don't do those things, and there's no reason to change it. So I guess I've got a couple of questions related to this. I'd like to have each of you tell me, number one, whether there is any good reason to have a different standard applicable to the FTC than applies to the Department of Justice when either entity is trying to block a merger. And number two, whether you would ever authorize the filing of an administrative complaint without seeking an injunction in federal court.
Senator,
we'll start with Mr. Chopra.
I agree that similar standards, there should not, market participants shouldn't have to navigate multiple standards whenever possible. I want to explore this more with you and others. One question I would have is with respect to speed of the overall proceeding. Administrative proceedings can sometimes be faster and cheaper for parties, so that would be something I would look into. As a general matter, though, I take your point that these issues may be best suited for federal court.
Mr. Phillips.
Thank you, Senator. It's been great to work with your staff over the last 6 years. My answer to the first question is I can't think of any reason whatsoever. The law should not operate as an arbitrage between which federal agency you appear in front of, and companies should not have to consider that question when deciding whether and how to pursue mergers and acquisitions activity. As I said to you when we met, personally, I need to learn a little bit more about the operation of Part 3, and if confirmed, I look forward to working with my colleagues, with career staff, and with you on that question.
Great, thank you. Ms. Wilson.
Thank you, Senator Leah. I think this is a very important issue. I think it's a matter of good government that businesses have clarity and predictability when they approach the government, particularly when you have concurrent jurisdiction, as between the FTC and DOJ. And so I do not believe there is a good reason for differentiated standards. There are people who will tell you that the standards essentially come out the same way, but I think conveying to businesses that there is the same standard has a great deal of value. In terms of where complaints are brought, I would think as a general rule for unconsummated mergers, seeking a PI in federal court would be my inclination. Obviously, there may be extenuating circumstances that should be considered, and I would want to talk with staff about that. But I think as a general rule, seeking a PI in federal court would be the right way to go for unconsummated mergers.
Okay. Mr. Simons.
Thank you, Senator. I don't see any reason why there should be two standards. I am one of those people who, though, agrees as a matter of practice that the same standard is applied, but I see no reason why it shouldn't be cleaned up and made very clear. In terms of where the FTC files its merger challenges, I think generally it should be in the federal court. There should be one bite at the apple. The litigation should occur in the federal court, and if the agency loses there, they shouldn't then be going to administrative trial.
Excellent. I appreciate that answer very much, and that is very helpful. In any case, whether we're talking about antitrust law or otherwise, but particularly relevant here, since we're talking not about a hypothetical, but about real-world situations, someone's fate as a litigant ought not be determined by the toss of a coin. The type of random decision that might dictate that a proposed merger be reviewed by this agency or the other. So when we have differing substantive standards that apply to one versus the other, and when one is required to go before a federal court and the other has another option, to me, that makes no sense. No one has ever explained to me an adequate reason why there ought to be two completely different systems. I understand the efficiency argument. That one has been made in the past. But the fact that something might be more efficient for the government ought not change someone's access to due process, which is what our system is all about. I see my time's expired, and the chairman's giving me that look, but I thank each of you for your thoughtful answers.
I never give